It seems everyone who has a complaint with the government goes running to the courts to solve their problems. Now, not only is this a bad idea, but what happens when the courts don't bother following the law anymore? We'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, and we teach the rising generation to be free. I'm glad you could join me. As always, please head over to that website, constitutionstudy.com. It's where you find everything I'm working on. You find articles to share. You can find my audios, my videos. You can head to the store. You can ask questions. You can comment. That's the central hub for everything we're doing here at the Constitution Study, including the events I'm going to, the classes I'm putting on, and anything else that's going on around the Constitution Study. So I hope you'll head over there. I hope you'll support the work that we're doing here. I hope you'll participate in what we're doing here. And with that, let's talk about courts and what happens when they start ignoring the law. We the people really need to get out of the habit of running to government to fix the problems of government. Seems every infringement of our rights is met with a chorus of cries to take someone to court. Now, while there is a time and a place to get the opinion of a court, we have changed them from the powerless arbiters of fact and law into oligarchs dispensing their opinions with the force of law. However, the question still remains, what happens when the courts don't bother to follow the law? Let's look at the request for the South Bay United Pentecostal Church et al. Versus Gavin Newsom, Governor of California et al. Now, South Bay United Pentecostal Church applied to the court for an injunction against Governor Newsom. This injunction was to prevent the state of California from enforcing his order limiting the occupancy of the church. From Chief Justice Roberts' concurrence, quote, "The order places temporary numerical restrictions on public gatherings to address this extraordinary health emergency." The church claimed that the governor's order discriminated against places of worship by placing greater restrictions on them than on other businesses. The court, which denied the injunction, seemed to focus on the question whether this was or was not a violation of the Free Exercise Clause of the First Amendment. From the concurrence, although California's guidelines place restrictions on places of worship, these restrictions appear consistent with the Free Exercise Clause of the First Amendment. But is that what the Free Exercise Clause actually says? Quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for a redress of grievances." Now, as I've said several times before, this is not a First Amendment issue. Governor Newsom is not an agent of Congress or the federal government. Since he is not acting under a law made by Congress, the First Amendment does not apply. Congress didn't make a law. But what about the Constitution of the state of California? Quote, "Free exercise and enjoyment of religion without discrimination or preference are guaranteed. This liberty of conscience does not excuse acts that are licentious or inconsistent with the peace or safety of the state. The legislature shall make no law respecting an establishment of religion. A person is not incompetent to be a witness or juror because of his or her opinion on religious beliefs." Now, since Governor Newsom has put the occupancy restriction in place to ensure the safety of the state, it is not a violation of this section of the Constitution of the state of California either, which means this is where the problems with the courts today really begins. From Justice Kavanaugh's dissent, quote, "I would grant the church's requested temporary injunction because California's latest safety guidelines discriminate against places of worship and in favor of comparable secular businesses. Such discrimination violates the First Amendment." Now, as I've already shown, since the law in question is not an act of Congress, it cannot be a violation of the First Amendment to the United States Constitution. This could be considered a violation of the California Constitution, Article 1, Section 4, if it can be shown that the order was not necessary to maintain the safety of the state. Now, since so many of the American people genuflect the opinion of these oligarchs in black robes, though, let's dissect their opinion. From the dissent, quote, "In response to the COVID-19 health crisis, California has now limited attendance at religious worship services to 25% of building capacity or 100 attendees, whichever is lower. The basic constitutional problem is that comparable secular businesses are not subject to a 25% occupancy cap, including factories, offices, supermarkets, restaurants, retail stores, pharmacies, shopping malls, pet grooming shops, bookstores, floors, hair salons, and cannabis dispensaries. Assuming all the same precautions are taken, why can someone safely walk down a grocery store aisle but not a pew? And why can someone safely interact with a brave delivery woman but not with a stoic minister? Justice Kavanaugh makes a very important point. The occupancy restriction is not being equally applied to everyone in California. While Justice Kavanaugh claims this is a violation of the First Amendment, it is actually a violation of Article 1, Section 4 of the California Constitution. Continuing in the dissent, quote, "In my view, California's discrimination against religious worship services contravenes the Constitution. As a general matter, the, quote, government may not use religion as a basis of classification for the imposition of duties, penalties, privileges, or benefits," close quote. That's from McDaniel versus Patty. Not only is the justice applying the First Amendment to a case where it plainly does not apply, he's using an opinion of another justice to supersede what the Constitution actually says. The First Amendment doesn't say anything about using religion as a basis of classification, only that the federal government cannot establish or prohibit its free exercise. The only language I can think of that comes even close is the prohibition of a religious test to hold office. Now, Justice Kavanaugh goes on to use another opinion to add language to the Constitution. To justify its discriminatory treatment of religious worship services, California must show that its rules are, quote, justified by a compelling government interest, close quote, and, quote, narrowly tailored to advance that interest, close quote. That's from Lukumi. Nowhere in the Constitution is the government authorized to use a discriminatory treatment of anyone under any circumstance without due process of law. There is nothing in the Constitution about compelling governmental interest, much less using it as a justification for discriminatory behavior. In fact, if we go back to the Declaration of Independence, we see that the primary compelling government interest is in protecting the rights of the people. Quote, "We hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed." That was the opinion of the dissenters. Well, what about those who prevailed? Quote, "Similar or more severe restrictions apply to comparable secular gatherings, including lectures, concerts, movie showings, spectator sports, and theatrical performance, where large groups of people gather in close proximity for extended periods of time. And the order exempts or treats more leniently only dissimilar activities, such as operating grocery stores, banks, and laundromats, in which people neither congregate in large groups nor remain in close proximity for extended period of time." In the opinion of Chief Justice Roberts and the others who concur, our rights and liberties can be infringed upon as long as there are others who are equally or more severely restricted. He also claims that your rights can be discriminated against as long as those with more favorable treatment aren't too similar to you. I wonder if they would feel the same way if it was their rights being infringed upon. Can the government restrict your freedom of speech as long as they restrict somebody else's more? Can the government deprive you of your life, liberty, or property as long as those they protect are dissimilar enough? If that's so, then what you have is not an unalienable right endowed by your Creator, but a privilege given to you by government. Also for the concurrence, our Constitution principally entrusts the safety and health of the people to the politically accountable officials of the states to guard and to protect. That's from Jacobson versus Massachusetts. Again, we see a judicial opinion placed above the supreme law of the land. Nowhere in the Constitution does it entrust the safety and health of the people to the government. The only place the word safety even appears in the Constitution is the authority in Article 1 as a justification for the suspension of the writ of habeas corpus. That's Article 1, Section 9, Clause 2. If I were on the court, I would have voted in favor of the injunction, but not for any reason given during the arguments. First, occupancy caps violate the California Constitution. Unless the state can prove that classifying religious gatherings differently than any other is necessary to maintain safety, these caps violate the state's free exercise clause. They also violate the right of the people to assemble. Quote, "The people have the right to instruct their representatives, petition government for redress of grievances, and assemble freely to consult for the common good." Now, neither of those are federal issues. And if it were the only question, well, I would have had to vote no. There is, however, a violation of the U.S. Constitution's privileges or immunities and equal protection clauses. Quote, No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The state has clearly deprived its citizens of the liberty to act as they will and the property of both their buildings and their rights. Furthermore, since this order restricts churches more severely than other organizations, the state has clearly denied their attendants equal protection of the law. For those reasons, and for those reasons only, I believe a federal court should enjoin the state from enforcing this order. Further proof that the courts can no longer be trusted to protect your rights, even the justices that believed the church should have gotten its injunction were horribly wrong. Quote, California already trusts its residents and any number of businesses to adhere to proper social distancing and hygiene practices. Tell me, where in the Constitution are the people required to be trusted by the government for anything? It is the people who trust those in government to act in accordance with their oath to support the Constitution. And it is the power of the people, when that trust is broken, to remove the offending official, either directly through election or by proxy of their elected representatives by impeachment. The very idea that the people need the government's trust in order to act is an inversion of the constitutional republic our founding fathers created and millions of Americans have fought and died for. From the Declaration of Independence, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence indeed will dictate that governments long established should not be changed for light and transient causes. And accordingly, all experience has shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. When will the American people have enough of these usurpations? Not just the governors trampling on our rights, but those on the courts rewriting our laws and constitutions to meet their ends. When will we have enough of suffering these evils? Will we come to our senses in time to alter our government at the ballot box? Or will we wait until the only option left is to do so on the battlefield? So, a couple of court cases in relatively rapid succession. I dealt with electors last week. This week, it's injunctions. It's equal protection. We have justices that have no clue what the First Amendment of the United States says, and we entrust them with interpreting it. We have justices that believe that their opinion supersedes what the words on parchment say, and we abide by it. Whether the church gets its injunction or not, this is a travesty of justice. Because even if the church is protected from these unjust, illegal, and unconstitutional laws, they would have gotten under such a bad principle, under such a bad precedent, that their rights aren't actually protected. They're not protected by law. They're protected by the opinion of a few people in black robes. If that doesn't scare you, if that doesn't bring to mind images of tyranny and oligarchies, I don't know what will. What good is the supreme law of the land if the people that are supposed to be judging the facts and law of a case ignore it? I don't mean just misunderstand it. I mean blatantly ignore what it says. Put the opinion of their predecessors above the supreme law of the land. What chance do you have at a fair trial? What do you have for a redress of your grievances when the people making the judgments have been corrupted? I don't know about you, but it scares me. And hopefully, it'll get you to go to the website, constitutionstudy.com, take this article, share it, show people just how badly corrupted our courts and our judicial system is, and then find out how we can change it. It's going to take a long time. This isn't a quick fix. But until we get our elected officials to hold these justices accountable for their bad behavior, not their opinion, their bad behavior, whether someone believed that the injunction should or should not have been allowed is not the question. As soon as I have justices putting judicial opinion above the Constitution, that is bad behavior. And Article 3 of the Constitution says federal judges only serve during their good behavior. And the job of getting rid of bad behaving judges belongs to your representative and mine. And it's about time we start kicking them in the backside and remind them of that fact. So hopefully I got your attention. Hopefully that was some good information. And hopefully I'll see you next time on the Constitution Study.